Collaborative divorce lawyer in Manhattan, New York. Ending a marriage does not have to mean going to war in a courtroom. In Manhattan, collaborative divorce offers a structured, private, and less adversarial way to resolve divorce issues without courtroom hearings. The goal is to negotiate property division and parenting plans and then submit final paperwork for court approval. A collaborative divorce is a voluntary process where both spouses and their attorneys commit to resolving all issues through negotiation rather than litigation. Each spouse retains a lawyer trained in collaborative practice and signs a participation agreement that sets the ground rules. The participation agreement is a binding contract requiring good faith negotiation and voluntary sharing of relevant financial information. A central feature is the disqualification clause inside the participation agreement. The disqualification clause requires both collaborative attorneys to withdraw if either spouse decides to pursue litigation. Because replacing counsel adds time and expense, this clause creates a strong incentive to reach a negotiated settlement. The process typically unfolds through structured joint meetings, sometimes called four-way sessions. In these meetings, both spouses sit with their respective attorneys to work through each issue step by step. Neutral professionals may join when needed, including financial advisors, child psychologists, or divorce coaches. Collaborative divorce is often confused with mediation, but the roles are different. In mediation, a neutral mediator facilitates discussion but cannot give legal advice or advocate for either spouse. In collaborative divorce, each spouse has their own attorney present during negotiation sessions to provide legal counsel and advocate within a cooperative framework. Litigation is typically more adversarial and places decisions about property, maintenance, and custody in a judge's hands. Litigated cases are filed in the New York Supreme Court and can involve discovery disputes, court appearances, and long scheduling delays. Collaborative divorce avoids most court procedures and hearings by resolving issues through negotiation before completing the required filing steps. The collaborative process begins when both spouses retain collaborative counsel and sign the participation agreement. Agreements in matrimonial actions must be in writing, subscribed, and acknowledged to be enforceable under Domestic Relations Law Section 236, b-3. After the agreement is signed, the couple may assemble a team to address complex financial or parenting questions. Both spouses commit to full, voluntary disclosure of financial information to negotiate from accurate facts. This approach can reduce cost and conflict by avoiding formal discovery tools like subpoenas or depositions. The team then meets in joint sessions to address property division, spousal maintenance, child custody and parenting time, child support, and other outstanding issues. Once all issues are resolved, the attorneys draft a comprehensive settlement agreement, sometimes called a marital settlement agreement. The settlement agreement is submitted to New York County Supreme Court at 60 Center Street for judicial approval. If the judge approves, the court issues a judgment of divorce. Collaborative divorce can resolve the same issues a judge would decide in a contested case, but with more control in the spouse's hands. New York is an equitable distribution state, meaning marital property is divided fairly but not necessarily equally. Under Domestic Relations Law Section 236, b, factors can include income and property at marriage and divorce, the duration of the marriage, and each spouse's contributions as a wage earner and homemaker. In a collaborative setting, couples can work with a neutral financial professional to identify, value, and divide marital assets. For child custody, New York courts apply a best interest standard under Domestic Relations Law Section 240. Collaborative divorce allows parents to develop detailed parenting plans with help from a child specialist when appropriate. New York provides guideline formulas for temporary maintenance under DRL Section 236, b-5a, and post-divorce maintenance under DRL Section 236, b-6. Parents can also calculate child support under the Child Support Standards Act and, when appropriate, agree on deviations with full understanding of the guideline amount. Retirement assets may require a qualified domestic relations order, which the collaborative team can help facilitate. Marital debts such as credit cards and mortgages can also be allocated between spouses through negotiation. Collaborative divorce tends to work best when both spouses can communicate respectfully and negotiate in good faith. It may not be appropriate in cases involving domestic violence, hidden assets, or serious power imbalances that cannot be addressed in the process. If the process breaks down, the participation agreement requires both attorneys to withdraw and the spouses must retain new attorneys to litigate. Benefits people often seek include added privacy in negotiations, less emotional damage, more control over outcomes, and faster resolution than contested litigation. Choosing the right law firm matters because collaborative practice requires a cooperative but prepared approach. Not every family law attorney is trained in collaborative practice, and the skills differ from traditional litigation strategies. Look for collaborative training, a strong focus on New York family law, and a communication style that supports productive joint sessions. The law office of Ryan Besinque represents clients in collaborative divorce, mediation, and contested divorce proceedings across New York City. If you want to explore whether this approach fits your circumstances, talk with a lawyer about the collaborative process and your goals. The law office of Ryan Besinque is located at 115 West 25th Street 4th floor, New York, 10001, United States, and you can reach the attorney at 929-251-4477 for a free, confidential consultation.